Hello, my name is Richard Albert, and today I'm joined by Will Partlett, Assistant Professor at the Chinese University of Hong Kong. And we'll be discussing courts and constitution making. And this again is another edition in our continuing series of video interviews at iConnect. Will, thank you very, very much for joining us.
My pleasure to be here.
Okay, great. So, Will, what interests you about constitution making?
Well, constitution making, I think, is one of those kind of dramatic moments in political change where really all these kind of rules, the fundamental rules of the game, kind of lie in the balance, and we see political players all kind of jockeying for position to I think to kind of craft the future, and in some cases, in some of my research, you see how self-interest plays a role in that, but you also see how they're looking forward to actually create a more just society, and more society with checks and balances. So I do think it's it's an exciting period to study, and it's also an important period to study too, because we see this happening more and more. We see either these waves of constitution making, like we saw obviously in the post-1989, post-communist world, where you have 28 countries drafting new constitutions almost simultaneously, to what we saw most recently in the Arab Spring, where we see across the Middle East new constitutions being drafted, and we can learn a lot from these moments, I think, in terms of thinking about the best ways to design processes of constitution making, and what really what are its prospects and what are its downsides, I think.
You have two areas of expertise. One is, of course, constitution making generally, and the other is the specific role of courts in constitution making. I want to get to that specific role of courts in constitution making, but first, let me ask you about the literature on the politics of constitution making, something that you're an expert in. Is there a dominant line of argument today in that literature on the politics of constitution making?
Yeah, I would say there is. And I would say that the dominant literature remains one that is quite idealistic, I think, and a highly romanticized view of constitutional politics and in constitution making. And I think this stems to some extent from from our some internal debates in the West, and in the United States and in Europe about and particularly, I think anxieties about judicial review, and how particularly courts playing a role in kind of judicially changing the Constitution. So as a result, there has been a push, and and I think there's a lot of writing about that just idealizes that we need to return this process to the people, and that that formal constitution making through popular processes such as constitutional conventions, referendums, these types of things are offer great promise in re-democratizing our things, and our political orders, our constitutional orders, and I think there's truth to that, absolutely. But I do think that misses another aspect that a lot of comparative experience shows, that there is that they don't offer just great promise, these moments of popular expression. Also, they offer I think quite large dangers, and in particular the dangers that they can be captured by charismatic leaders, they can be captured by very powerful parties, that majoritarianism can take over and ultimately take over the process and use constitutional rules, what David Landau calls abusive constitutionalism, using these constitutional rules to essentially weaken checks on your power. So there is this downside, and that's something that I think needs to be added to this literature on constitutional politics. And once we have that, we have a more balanced view of constitutional politics. Then we can start to figure out how can we turn these things into moments of promise, and avoid these these times where they get captured and they become really moments of disillusionment and reimposition through through these formal rules. I mean, these obviously constitutional rules matter a huge amount. Formal rules design the structure of the state. These are dramatic moments, as I said, and they offer great promise to set up checks and balances, but can also offer an opportunity for someone to win a short-term political fight by essentially eliminating the institutional base of their opposition. So I do think that this downside needs to be needs to be understood and put more into the theoretical literature as well. And I think then we can have a much better understanding of how to actually go forward with this, and think much more realistically, I think, about constitutional politics in general.
So on the peril, the dangers of constitution making, you've carved out an area of expertise with regard to constitution making in Russia and post-communist countries. So I wonder, on those case studies, have you been able to learn any generalizable lessons that could be applied elsewhere?
Yeah, I think so. I mean, I think, obviously, the study of the former Soviet Union is context specific, in that, you're looking at a region of the world that has a long political history of personalistic and charismatic leadership, going back for centuries. But at the same time, I do think we see common themes emerging in some of my studies of that region, and looking across the globe, maybe towards South America. So this idea that, as you raise, this idea that we have that constitutional politics and constitution making is dangerous. Is something that actually independently, a colleague of mine at Florida State, David Landau, came to a similar conclusion studying Venezuela and Bolivia in South America, and we see similar. And particularly there, the abuse of majoritarian institutions, and particularly kind of specialized majoritarian institutions, such as constitutional conventions and referendums, were common, kind of mechanisms that were used by these, by these elites, and particularly these charismatic leaders. So Hugo Chavez in Venezuela, Boris Yeltsin in Russia. They use these as ways of saying, well, look, this is democratic. It's democratic for me to win an election for the Constituent Assembly, and then this Constituent Assembly then, can reshape the entire institutional framework of the state in my interest, no less. So, we see generalizable, I think, things coming out of this, and I think in general goes again to this I was talking about before, kind of placing something seriously on the research agenda for those interested in constitutional politics about how to limit this type of kind of partisan exploitation of these institutions, and how to go forward and how to think about ways of doing it, because it is something we see, and obviously something we're seeing in Hungary at the moment as well, the use of constitutional rules to entrench power by Viktor Orban. Kim Lane Shepley's written about this a fair amount. So, I think this is something that we see happening around the world. It's not just limited to the former Soviet Union. Obviously, it's context specific in some of its ways, but something we should be aware of, and I think we should introduce into the broader generalizable writing on this type of constitutional politics.
Well, I want to take us in a moment to the role of courts in constitution making, but first, one more question that is, I think, a vexing question, a vexing field of inquiry. It's just so fascinating, and I'd love to get your thoughts on it. And it has to do with the relationship between political culture and constitutional structure. So, this is the debate about what drives what. Does constitutional structure shape political culture, or must constitutional structure necessarily be shaped by political culture? I've always thought that the answer is more nuanced than some people might think it is. It's obviously, to me, a bidirectional relationship. One affects the other as it is affected by what it is affecting. I wonder, in your studies on Russia, Eastern European countries, Central Asia, whether you've come across any data points that help us better understand the relationship between political culture and constitutional structure.
Yeah, well, this is you put your finger on one of the most one of the most interesting and most contested debates, and I would agree with you to start with, to say that I do think that the two interact. And thinking about the region that I look at, the 28 countries of the former Warsaw Bloc countries of Eastern Europe, the former Soviet Union, as well as the former Yugoslavia. I do think we can see, obviously, all of those countries had similar institutional structures. They had the Leninist, form of legislative supremacy, where you had a constitution that set up the state. But ultimately, the unwritten constitution was that the Communist Party was in charge. So all of these countries, when they emerged from communism in the late 1980s, early 1990s, had similar initial institutional conditions. And it is interesting to see how political culture shaped, to some extent, some of the choices that were made. In Eastern Europe, the former Warsaw Bloc, we see, Poland, the Czech Republic, Slovakia, Hungary, much more of a tradition, historical tradition, political culture tradition of parliamentarism. They're more, and they identify more with Europe. In those countries, the parliaments played a bigger role. That's not to say that there weren't attempts at more charismatic politics. I mean, Lech Walesa in Poland obviously was attempting to, at some points, to play a role in pushing. But we do see, that playing somewhat of a role, I think. And as we go further east, we see more, particularly, Turkmenistan, Tajikistan, and Uzbekistan, highly personalistic, sultanistic regimes. Obviously, a single, there, in many cases, it was a single leader who was in charge, and institutions were not as important. But what is interesting is to look at the countries in the middle, and I think Ukraine is one that, obviously, is a very interesting one to look at. Has kind of a split. In some regards, it was part of the Habsburg Empire in one part, in other regards, part of the Russian Empire, and you see how their rules and formal rules played a very important role in the maintenance and its constitutional transition. Not time here to talk more about it, but I do think, looking across a broad range and looking specifically then at qualitative case studies of these specific regimes can actually yield a lot of interesting conclusions about, this interplay, and that it's not simply, in some areas political culture might completely dominate, but in others you do see real role, formal rules really do matter. So I guess my answer is that it's context specific.
Yeah, I appreciate that, and I agree entirely with you. So now this is really what I was really excited to talk with you about is the work you're doing now on the role of courts in constitution making. This is, I think, really path-breaking stuff, and there aren't many people writing about that, which is why I'm so excited to have you today on iConnect. So your current work explores how we can conceptualize a democratically legitimate role for courts in constitution making. So I wonder what kind of roles, possibilities do you envision in your work for the role of a court in constitution making, a role that, as you say, should be democratically legitimate?
Yeah, well, at first blush, it seems pretty unlikely that courts should play any role at all in constitutional politics. As I say, going back to a lot of the writing in the U.S. and the American constitutional tradition, there, so much of constitutional politics and amendments is about overcoming judicial kind of amendments. That we just don't think of it that way. But there is an intriguing amount of judicial involvement, as a comparative experience, where courts have involved themselves in what I think in the most legitimate way, and actually improving the politics of constitution making. And this goes to kind of as part of my interest, again, in trying to figure out ways of improving the politics, of decreasing the likelihood of these downsides, these dangers of constitution making. And I do think courts have stepped in. One example is the rise of this unconstitutional constitutional amendments doctrine. I know you had Yaniv Rosnai on, who talked about this in detail. I mean, this is a very interesting doctrine where courts are literally stepping in and actually striking down amendments as being, in violation of what, in India, the basic structure, or in Colombia, and they're actually seen as a substitution of the Constitution rather than an amendment. So we're seeing, courts stepping in, and judges actually seeing themselves play a role in improving, the politics of constitution making and of trying to stop, what some people in the American political process school call partisan lockups. The attempts to use formal rules to, formal constitutional rules to essentially entrench power, to reduce checks and balances, and that courts see themselves as playing a role in kind of blocking this. And I think it's exciting. It's an area that requires a lot of work because there are significant limitations on what courts can do, but I do think it's an area worth considering, and how particularly courts can play a role in kind of reducing these kind of dangers of constitution making.
Let me ask you a question about kind of the worries or the risks that one might have in the face of a court asserting itself in the process of constitution making. So as a descriptive matter, we can imagine what the proper role of a court is. The separation of powers in many countries governs what the proper role of a court is. Although, as you suggest, in India, the court can depart from the conventional understanding of the separation of powers and what that requires of a court. But in terms of the normative perspective, what should be, in your view, the limits of the court's role in constitution making?
Yeah, I think this is something I'm working on now. But first of all, I do think courts need to be limited from taking on positions whereby they can themselves block what are large scale public deliberations that have taken for a while, that essentially that the courts themselves can play a kind of entrenchment role themselves. And we've seen this. There are examples across in the comparative experience that I'm looking at now where courts can ally themselves with powerful elites who essentially are losing democratic support, and the courts themselves can then step in and play, then can become kind of themselves a part of the problem. So I think one of the serious questions that needs to be answered in this field, and there's a emerging field, as you say, is to how to limit courts. How can courts, and how do we get courts that are acting in terms of actually helping to improve the political process, rather than, so we then have to decide, well, what does that mean, and how do we limit their capacity to undermine the political process when it is working well. And so that's, and I think those are very difficult questions to answer, and ones that I'm kind of beginning to think through. But we do see examples of courts doing this. As the Colombian example of, you've had Carlos Bernal on this talk show as well, and I think it's important to see that certain courts do actually act. They actually see themselves really as playing an important role in improving the expression of the popular voice. So really the question then becomes, how do you get courts to do that without having them go too far? And those are difficult questions. One answer might be through contextual design in the Constitution, limiting them to only certain types of questions, actually explicitly. But I think more clauses on how you control. We see some of this in state constitutions in the United States, where they put real textual limits on what courts can and can't do in policing constitutional change. But I think this is an area that is, as you put your finger on, a very important one in understanding, so that courts don't become part of the problem as well.
I'm glad you mentioned the United States, because that's exactly where I wanted to take the conversation next. What role do you envision for federal courts in the process of U.S. Constitution making and redesign? Now, in many respects, this is like a hypothetical question, right? Because it's hard to imagine an Article 5 amendment today. Perhaps for a generation, we just don't know if political majorities will be able to scale the great heights that Article 5 requires of them. But just hypothetically, what role would you envision for federal courts in the Article 5 process?
Well, it's a good question, and one, actually, you're right to say that it seems very unlikely that this would happen, but we have seen at times in American history, particularly in the 20th century, examples of when scholars have really been debating this question. When we've seen significant areas so in the 19-teens and 1920s, there was a lot of debate about whether there were any substantive limitations on the power of the amendment process through Article 5 to actually amend the Constitution. And then in the late 1970s and early 80s, surrounding the Equal Rights Amendment, a very interesting debate between Dellinger and Tribe about whether courts should play a role when there was a debate about the Equal Rights Amendment, whether the Equal Rights Amendment itself was still valid, or if it had lapsed. Who has the power to determine these questions? I think so. There really are, in this debate, Dellinger argues that courts are needed to ensure legitimacy. Otherwise, we simply have, what if the president and Congress disagree on an amendment? We haven't seen that, obviously, but if that were to happen, we need someone an institution to decide who's right. Another big question that we saw most recently in the early 1990s is one whether who actually certifies whether an amendment is valid. Is it Congress through promulgation, or is it the executive branch through the archivist? And that remains an open question. So I do think there are significant questions of federal amendment process where the courts probably, in my view, should play a limited role, but actually probably should step in to kind of give some finality to some of these procedural questions. Now, when we get to substance, now that's probably somewhere where courts probably should not involve themselves in the U.S. amendment process, largely because I think on substance our process is supermajoritarian enough that if you get through, as you say, climb the great heights of Article 5, you have a pretty mobilized majority. But when it comes to procedure, are amendments still valid? Who certifies whether an amendment is valid? These types of questions, I do think courts can play a role in solving and solidifying some of these disputed questions.
Yeah, you mentioned American state courts and state constitutions. Could you explain for our viewers the differences in terms of court practice as relates to state constitutional amendments and U.S. federal constitutional amendments?
Yeah, well, I mean, the first major difference is the states are constantly amending and often replacing their constitutions. We see, in some ways, we've seen work by Mila Viersteig and others on this, that you see a lot of, the states look a lot more like the rest of the world. They're a lot less exceptional because they are constantly amending and replacing. And as a result, actually, interestingly, you actually see state courts playing a very important role in this process. I have a paper now which talks about what I call the common law of the American states, where they actually help to regulate the process of replacement. And this is where state courts are. So, and we also see state constitutions where they have actual text that talks about the role of courts in policing amendment and replacement. We see in California, for instance, a very active, vigorous judicial review on whether you have a revision, which is a whole-scale replacement, or an amendment. And obviously there, the courts are saying if it's a revision, you have to go through a procedural process that involves a constitutional convention. You can't use a referendum for this. So we do see the states doing the kind of things that I'm interested in, which is really kind of seeking to improve the politics of constitutional change, whether it be amendment or replacement. And I think it's another very interesting source to look at, to kind of begin to build an understanding of what is a democratically legitimate role for courts in this constitution-making process.
Will, you'll have to forgive me because I promised you our talk would take about 15 minutes, but it's taken much more than that. But this is just so fascinating. I want to keep going, but I'll resist. I'll exercise some self-restraint and just maybe limit myself to 2 more questions if I could. The first is, what kinds of questions out there remain to be answered in connection with the role of courts in the constitution-making process? This is still a very new field. You are one of the few who are writing about it, at least in the present moment. And so what kinds of questions do you think need to be answered as we begin to develop this field of inquiry?
Well, I think one of the really pressing questions is we see, I've talked about, the role of courts in policing amendment. So, courts, as I say, in Colombia, India, and around the world are amending, declaring constitutional amendments in violation of norms or the Constitution. But what we haven't seen as much is courts playing a role in policing replacement processes. So the actual, when a new constitution is created, and this poses a whole new range of problems, of course, because when the Constitution is replaced, then the argument then becomes that the people have spoken, the constituent power is activated, and that this constituent power is unregulatable by courts. So you run into more normative problems, and you also just run into more problems of, well, when a constitution is suspended, under what power does a court operate? If there's no interim constitution, if there's no formal kind of rules, how would a court operate? What would limit it? So I think constitutional replacement in courts is something that is a very important area of research to look at, because we do see constitutional replacement as one of the most pressing problems in this issue of abusive constitutionalism, where we see formal rules being deployed. If you can't do it through amendment, then you just do it through replacement. So I think that's an issue. And second, really, is to look more closely at how can we make courts, how can we limit courts, as I've talked about, how can we keep them from becoming part of the problem as well, but also how can well-meaning courts that are doing things that are actually improving politics, how can they be more effective? I mean, we see examples both in Venezuela and Russia. The courts actually were trying to kind of block and check the power of these charismatic executives, and they ultimately were unsuccessful. So thinking through what kind of strategies the courts use, because obviously they're taking on very powerful figures. Courts, as we know from, they have neither the power of the purse nor of the sword. How do courts operate? How can they strategically? When should they intervene? That's a big question. Timing. How should they intervene? These types of questions, I think, there's just a whole range, and I do hope more people will get involved in this field, because there really are just numbers of questions, interesting questions, and comparative experience teaches us a lot about, I do think, about how we can begin to think through some of these questions.
Well, there are great people writing in the field. Kim Lane Shepley, David Landau, my colleague here at iConnect, it's a really great group to be joining. Last question. What are you working on right now? What are the projects that you're researching and writing about now? You've given us kind of a few insights into some of the things you have written and are currently writing, but what's next for you down the road?
So right now I'm working on a paper that I call the Law of Constitution Making, and it actually responds to a few of the things I was just talking about. In particular, it looks at how courts might be better positioned in regulating and improving the politics of constitution making by, instead of reviewing constitutional amendments that have already been passed, as they do in the unconstitutional amendments doctrine, that actually reviewing the laws that play an important role in determining the balance of power in constitution-making moments. And I think in this, this includes laws like electoral laws. How do you elect a constituent assembly, for instance? This includes laws about referendums. How do referendums, how should they be worded? What's the turnout percentage that you would like? Essentially, what are the details of these kind of laws that play a huge role in determining balance of power? And we see from comparative experience that one of the ways that these institutions, these kind of specialized institutions, can be abused is through essentially manipulating the details. We see Chavez in Venezuela, essentially drafted the electoral law for the Constituent Assembly that he later dominated, essentially by drafting it in such a way that it would advantage him. So we want to think. So my argument there would be that courts should play a role at that point. Before you've got these dominant coalitions already in position, where courts are really in a weak position, they should intervene earlier. And thinking about ways for them to review this, as I say, the law of constitution making also puts them in a less of a normative position where they're having to strike down actual amendments that are part of the Constitution. Instead, they're doing what courts do all the time. They're reviewing laws, and they're reviewing them on the basis, I would argue, maybe some sort of textual part saying amendments. Elections to any kind of constituent assembly for a replacement process should be fair and include a diverse range of interests, something like that. And they can use that as a way to review. So I think that this is an area that I'm looking at now as one way of beginning to solve these big problems that, as you say, the field that we're wrestling with, that I'm wrestling with, David Landau's wrestling with, Kim Shepley's wrestling with. These type of things that we're seeing happening in practice, and how might courts help fix this? So I think that's taking up a lot of my time at the moment, so I think that's I'm hoping that this project will further get me to think too as well about this is ultimately one about where can courts intervene effectively and in a way that they're less likely to become, again, part of the problem.
Well, Will, thank you very much. Next time we talk on iConnect here, I'll ask you about how to stem the tide of the rise of judicial supremacy. That, I think, is something worth thinking about, especially in the context that you are discussing, the role of courts in constitution making, the very kind of thing that by conventional wisdom should not involve courts. So that'll be for the future. But thank you so much, Will, for walking us through very interesting questions about constitution making, about the role of courts in constitution making, and also about questions that you think deserve more attention among comparative public scholars. Very, very interesting. Thank you so much.
Thank you for having me.
Okay, Will. Bye-bye.